As we all know, in the state of Israel, many legal proceedings can be ongoing and sometimes take many years. In order to expedite and shorten the proceedings, there are several types of claims that can be filed in an expedited procedure and in a manner that shortens the proceedings. In fact, these are claims that are considered special and can be filed in accordance with the procedures and regulations in procedures designed to expedite those proceedings. As stated, only certain claims can be filed in this way. Chapter 16 of the Civil Procedure Regulations contains provisions that discuss the manner in which a claim is filed in an expedited procedure and determines which claims may be filed in this proceeding and in this manner, as well as the various procedures in these claims. The amount of the claim in a speedy judgment. The first condition for filing a claim in an expedited procedure, according to the SADA regulations, is that it is a claim in a maximum amount of up to an IS 75,000 plus an index. In that case, the court may decide to transfer a claim to ordinary proceedings or vice versa, to the extent that it has seen that this is a step that benefits the clarification of the claim. Attach affidavits and references relevant to verifying the statements of claim. When dealing with a fast-track litigation proceeding, and as opposed to filing a regular monetary claim, the plaintiff must file affidavits, references, and expert opinions, along with filing the lawsuit itself. Defendant is also required to attach and file the relevant affidavits upon filing a statement of defense. These affidavits must be accompanied by legal references so that all the information and data will be presented to the parties and the court at the beginning of the case management. In addition, the parties will have to attach to the statement of claim a list of the relevant documents in their possession and related to the file, as well as a copy of each document on the list, thus avoiding the necessity and need to conduct document disclosure proceedings. The steps in quick judgment. Deadline for filing a statement of defense in a fast-track lawsuit. The statement of defense must be filed by the defendant within 45 days from the date of receipt of the claim. Appropriate references and affidavits must be attached to the letter of defense. The plaintiff will be entitled to file his response within 15 days from the date of receipt of the statement of defense. Affidavit of chief testimony, hearing and judgment. The affidavits of the main witness. The parties are to be filed within 45 days from the date of filing of the defense brief. The court will decide on the date of the first hearing within 6 months from the date of filing the statement of defense. The hearing regarding the lawsuit will take place, if possible, on one day when all the affidavits will appear. If necessary, the court will extend the hearing by a few more days in favor of questioning the witnesses. The judgment will be given by the court within 14 days of the conclusion of the hearing. This is a procedure that is much quicker compared to managing a regular lawsuit. When you go to an Israeli litigation lawyer, it is important to consider and examine what is the most appropriate and correct route for you to handle the claim. The characteristics and benefits of a fast-track lawsuit. A fast-track lawsuit is intended to shorten the legal process and expedite the issuance and receipt of the judgment. The characteristics of the procedure are intended to bring about a resolution, as quickly as possible, of the dispute. The party authorized to hear such a claim is the magistrate's court, and this is natural, because when it comes to amounts of up to an IS 2.5 million, the claim is conducted in the magistrate's court. As stated, the claim can be filed in a speedy court order up to the amount of an IS 75,000. A fast-track lawsuit cannot be a lawsuit under the Compensation for Road Accident Victims Act, or a class action lawsuit, for which there is a separate procedure. In the case of a claim under summary judgment, if the authority to defend has been granted, it will be heard as a speedy judgment only when the amount of the claim does not exceed an IS 75,000. Even in an ordinary lawsuit, it is possible with the consent of the parties, and as far as it is appropriate, to discuss it in a speedy court order. Attach documents and references. The statement of claim in a fast-track lawsuit requires the attachment of relevant documents, including a list of relevant documents, an affidavit, expert opinions if any, and legal references. The statement of claim in the case of a claim in a speedy court order will be found and submitted to the defendant together with a summons. The statement of defense must be filed within 45 days from the date of filing the statement of claim. The plaintiff will be entitled to file the reply within 15 days from the date of issuance of the defense. The conditions for filing a counterclaim in a summary judgment. Filing a counterclaim in a speedy judgment is possible if the following conditions are met. The counterclaim will not include new litigants, unlike the normal procedure in which new defendants can also be attached. The amount of the claim is not higher than an IS 75,000. The subject of the counterclaim and the subject of the main claim is one, or alternatively, the two claims filed are due to the same circumstances. In a fast-track lawsuit, the court will be entitled to hold, within 30 days from the date of filing of the last defense brief, one preliminary hearing. If possible, the judge who presided over the hearing at the preliminary hearing will not be the one to hear the lawsuit. The preliminary hearing can also be conducted and discussed by a registrar, during which the court will be entitled to examine the degree of suitability of the particular claim for an expedited procedure. Unlike the ordinary procedure in which the plaintiff is the one who first files an affidavit of primary testimony and then the defendant, when it comes to a fast-track lawsuit, the two parties will file the affidavits of the main witness together, within 45 days from the date of filing the last defense. The affidavits of the witnesses must be accompanied by all the documents and certificates on which the witnesses are based and rely on their affidavits. The date for hearing the claim will be determined by the court no later than 6 months from the date on which the last letter of defense was filed. In a speedy trial, the hearing of the lawsuit will end in just 1 day. A summary of all the arguments of the parties will be presented orally in the same hearing after the conclusion of the following evidence. The court will decide and give a verdict within 14 days at the latest, with a clear and concise reasoning regarding its ruling. A fast-track lawsuit procedure is also suitable for monetary claims involving contracts, loan agreements, invoices, etc. However, this procedure is not suitable for filing claims relating to and dealing with personal injury, as well as claims dealing with or relating to real estate ownership and possession. The plaintiff is required to attach to the statement of claim all the support and evidence in his possession, invoices, documents, correspondence, affidavits, and more. An expert lawyer and a leader in the field of civil commercial law, Scheiman Hahn Law Office and Notary, is considered one of the leading and highest quality in the field of civil law, commercial expedited litigation, real estate, enforcement proceedings, insolvency, wills, and inheritances. The firm's legal team is skilled, experienced, and dedicated, and includes leading and senior lawyers who will provide you with guidance, advice, and representation that meet the high professional standards. We will accompany and represent you in full cooperation and personal treatment, all the way to the completion of the task on the best side and the achievement of the best legal result for you. We are at your service in full availability, and we will be happy for you to contact us and get help from our team of experts. This way you can be calm, confident that you will receive a quality legal response with responsibility, dedication, and personal treatment.